Hello everyone, welcome to JAIIB CIB Prep. In today's video, we'll discuss about unit number 7, Banker Special Relationship. In this unit, we'll discuss what is a mandate, what is a power of attorney, banker's lien, right of set off, right of appropriation, and then we'll practice some questions. So without further ado, let's start our video. So usually a bank account is operated by an account holder, the person who opened it, right? However, sometimes the account holder may allow someone else, like a family member or a friend, to operate the account on their behalf. But this is done using a legal document, which creates a special relationship between the banker and the customer. Um, this special relationship can be created by a mandate, number one, number two, by power of attorney. So the question arises, what is a mandate? A mandate is a written instruction by the account holder that gives permission to another person to operate the account. For example, a person named say R gives a permission to person named Y. Now this permission, this written instruction given by R to Y is a mandate. Now, mandate is used when the account holder temporarily wants someone else to withdraw money, deposit check, make payments. And some of the key features of mandate are the account holder has to inform the bank in writing. Now, why bank will believe that why has the authority to withdraw the money, to deposit the check, to make the payment? Because R has specifically informed the bank in writing about this mandate. The signature of the person is verified by the account holder. It is mandate is usually for a short period of time, and organizations or companies cannot issue mandate. They have to use power of attorney, and the mandate ends when account holder dies, becomes mentally unfit, or goes bankrupt. Now let's talk about power of attorney. Um, if you want another example on mandate, let's discuss one more example. Then we'll move forward to power of attorney. Say if Mr. S is traveling abroad for 3 months. Now, what he can do, he can give a mandate to his son to operate the bank account and pay household bills. So, by this manner, the mandate will work. Power of attorney. A power of attorney is a legal document where one person, called the principal, authorizes another person, called the agent or attorney, on to act on their behalf. Now, there are two types of power of attorneys. Number one, general power of attorney. Number two, specific power of attorney. General power of attorney gives broad powers, like opening account, signing checks, selling property, etc. A specific power of attorney limits to a specific task. As the name suggests, it is for a particular purpose or transaction. Specific tasks like selling a house or managing one bank transaction or another. Now, what are the key points about power of attorney? It gives legal authority to act in various matter. It must be notarized, meaning to say it must be signed in front of a government official or notary. The power of attorney holder must sign as per pro on behalf of, say, Mr. X, HD constituted attorney. And the principal can cancel this power of attorney at any given point of time. The power of attorney also becomes invalid when the principal dies. When this principal dies, goes insane, or is declared bankrupt, similar to mandate, right? Now, let's take example. Company director gives a general power of attorney to the company secretary to manage all bank related tasks, sign checks, or attend meetings on his behalf. So in this manner, power of attorney will work. Now you have to remember that a company cannot issue a mandate. A company can use power of attorney. Let's talk about declaration of powers with respect to mandate slash power of Attorney. The joint account, all account holders must sign the mandate or power of attorney. With respect to partnership firm, all partners must approve the mandate or power of attorney. With respect to companies, only authorized person as per board resolution can give power of attorney if they are allowed to do so. Legal guardian or executors like fiduciaries, they cannot appoint someone else unless clearly allowed. If multiple agents are authorized, the bank must receive the clear instructions for multiple agents. Clear instructions should be given, should be stated whether agents can act individually or jointly. Bankers lien. So let's talk about some of the bank's right. A lien. What is a lien? A lien means the right to keep someone else's property until the person repays the loan or clear dues. In banking, a banker's lien means the right of bank to hold or even sell the customer securities or goods to recover its dues. Now, why it is also known as implied pledge? It is treated as an implied pledge. Why? Because even without an express agreement, the bank can act as if the customer has pledged the assets. Now, let's take an example. If a customer, say a customer, takes a loan and gives fixed deposit receipt to the bank, FDR, fixed deposit receipt, or shares as security to the bank or any kind of security to bank. Now, if this loan has not been repaid, the bank can sell the securities to recover the money, the loan amount. There are two types of lien. We'll talk about exceptions later. Yeah, there are two types of lien: general lien and particular lien. In general lien, the bank can retain any assets of the customer until all dues are paid. Example: bank holds FD even if not linked to a specific loan. What is particular lien? The bank hold property only related to the particular loan or transaction. For example, if gold is pledged for a loan, the bank can keep the gold until that specific loan is repaid. Now, where this lien can be used? It can be used for goods received in normal course of business, goods received in the normal course of banking. This is one. Secondly, this should not be used for any special purpose for which goods are mentioned. There should not be any agreement between the customer and the bank. There should no agreement stating that lien cannot be used. Stating what? That lien cannot be used. And number four, goods held in the same capacity as the account. Now, what are the exceptions where bankers' lien cannot be used? Number one, if articles are kept only for safe custody. So, if gold is put in the locker, bank cannot use the lien. Documents given for any specific purpose. So, if there is any specific purpose for which documents are given, then also bank cannot use lien. If things are left by mistake, for example, a person visited the bank. He has a file with him in which the life insurance policy documents are there, share certificates are there. So, and he left it mistakenly in the bank premises. So, the bank cannot use those policy documents or share certificates. So, articles left unintentionally are not subject to banker's lien. If the loan has not been matured yet, the banker's lien cannot be exercised. For stolen goods, a bank cannot claim lien on such stolen goods. And if bank has a right of set off, then lien cannot be applied at the same point of time. Now, we were talking about set off, so let's understand what is a set off. So set off means adjusting money a customer owes to the bank using the money the bank owes to the customer. Okay, let's simplify it. If you have two accounts in the same bank, one has a loan, you owe money to the bank, and one has a deposit. So if a person has a loan account, what does it imply? That he or she owes money to the bank, and if he or she has a deposit account, what does this imply? That bank owes money to this customer. And now, if you have two accounts in the same bank, one loan account, number two deposit account, the bank can use the deposit account to reduce this loan. Say you have savings account of 20,000, you are money with the bank, a loan account with an unpaid amount of 15,000. Now the bank can use the 15,000 from your savings account to settle the loan. So this is called set off. What are the conditions for set off? Number one, it can be based on law or agreement between you and the bank. The bank should normally inform you before using set off unless it is automatic. There must be no agreement that removes the bank's right of set off. The bank and you must owe each other definite. There must be a certain amount. Bank cannot use set off for unknown or future liabilities like guarantees not yet triggered. If the account is under the trust, the bank cannot use set off against your own loan. Keep that in mind. And the bank cannot mix your account with an account of deceased person for set off. Let's talk about the term we have just introduced, automatic set off. So when does it happen? So for automatic set off, generally no notice is required to be given. So when does it happens? When the person dies, when the customer dies or becomes insane, when the business is declared insolvent, when bank receives a court order, when bank is told that someone else has right over the customer's money, then automatic set off works, and when mortgage assets become due. And who cannot use this set off? When can bank cannot use this set off for trust account amounts, for any future debts or uncertain amounts, or there is a credit in another branch. So bank cannot use set off for this. So branches are one unit for bank, but not for customers. Okay. Let's move on to the last right, right of appropriation. What does we understand by right of appropriation? When a customer pays money to the bank but has multiple loan accounts, multiple loan or accounts, the question is which loan or account should the payment be applied to? For example, say you have two loans, one personal loan, one car loan. You deposit 5,000, personal loan for 10,000, say, and car loan for 5,000 only. You deposit 5,000. Now the question is to which loan this amount should go, right? Whether it should be applied to personal loan or car loan. Now there are three scenarios for it. Say customer say clearly, now you tell the bank that this 5,000 is for the car loan. Now the bank must use it for car loan only. When you don't give any instruction, meaning to say when customers gives no instruction, in that case the bank can choose to use the amount for any loan, like the older one or higher priority one. When neither says anything, the law says the money should go to oldest date first, and if dates are of same age, then it should be split equally. There's a famous case, Sarewal Industries versus Odisha State Finance Corporation case, 1985. In this, the court stated that if there is no agreement, the bank will use the payment to pay interest first. So the question was whether to pay the interest first or the principal, or whether they should be paid off simultaneously. what should be the scenario? So if there is no agreement, the bank will use the payment to pay interest first and then the principal amount. I hope this is clear to you. Now let's move on to our exercise questions. So number one is lien is or an dash of creditor to retain possession. What is lien? Lien is a right. So option A is the correct answer for this question. Banker's lien is an, we have just discussed it, it is an implied pledge, making B the correct option. Right to appropriate the debit balance in one account with credit balance in another of same customer by banks is called set off. C is the correct answer. Mandate is, see, power of attorney is a stamped agreement. Mandate is not a stamped agreement, so it is an unstamped agreement, making B the correct option for this question. Person to whom a power of attorney is given is called dash, and who gives it is called dash. So it can be agent or principal or donor. So D is the correct answer for this question. Okay, so let's move forward to more questions. Which of the following is not true about mandates? A mandate can be withdrawn anytime by the account holder. This is correct. Institutions are allowed to issue mandate instead of power attorney. No, institutions are not allowed. So B is the correct answer for this question. Let's read other options as well. A mandate allow the mandatee to operate the account on behalf of the account holder. Yes, this is correct. All statement given uh, above are correct. So no, B is not true. So B is the correct answer for this question. Which of the following statements regarding power of attorney is or are correct? A general power of attorney is issued for specific purpose and limits the authority of doing. No, it is not general, it is particular power of attorney. So one is not correct. The power of attorney document must be executed in presence of notary public. Yes, this is correct. A power of attorney can be revoked by principal at any time for future transactions. This is also correct. So 2 and 3 are correct. So B is the correct option for this question. Which of the following statements are true regarding a banker's lien? A banker's lien is an implied pledge which allows the banker to retain possession of goods and securities until debt is paid. So this statement is true. A banker can exercise a lien over goods left at the bank by customer regardless of whether they were deposited in the ordinary course of banking business. No, if left mistakenly, bank cannot use it. So this is not correct. A general lien allows the banker to sell goods in case of debt default, while a particular lien only allows possession of goods related to a specific charge or dues. This is correct. A banker may exercise a lien over stolen goods if no stolen goods. So not correct. A banker has the right to exercise a lien on goods or securities if a specific agreement of lien is made between the bank and the customer. This is correct. So 1, 3 and 5 are correct. So C, option C is the correct answer for this question. With which of the following statement about the legal principle of the right of set off in banking transaction are correct? A bank has the right of set off between two or more accounts maintained by a customer when there is mutual creditor relationship. This is true. The right of set off can only be exercised if debts are not due and are contingent. This is not correct. Debt should not be contingent, it should be certain. A bank can set off a customer's credit balance against the debit balance of same account without any notice to the customer. No notice should be provided. So this is not correct. For the right of set off to be exercised, the debt must be for certain sums and both the claims and the cross claims should be definite. Yes, this is true. The right of set off can be applied to debts that are contingent and not yet due if the debts are within the same bank branch. No, debt should be due to be in order to use the right of set off. If a customer has a credit balance in a trust account, the bank cannot apply the right of set off against another account held by the customer. So this is also not correct. Trust accounts are exempted. Customer account in one branch cannot be set off against, uh, so there must be mistakenly the bank cannot apply it, so bank can apply. This question should ask for, because then there will be no option. So bank can apply. So if customer has credit balance in trust account, the bank can apply the right of set off against that is what it makes an incorrect statement. A customer's account in one branch cannot be set off against the debit balance in an account held at different branch of the same bank. So this is also correct, because customers account a different branch of the same bank cannot be combined for set off. So A is the correct answer for this question. Which of the following assertions best reflect the legal principles regarding the appropriation of payments in banking transactions involving multiple debts? In the absence of an express appropriation by the debtor, the bank as creditor is legally bound to apply the payment received in the following order. First, towards overdue interest, correct, then principal, correct, then lastly towards any future liabilities, unless the debtor has specifically directed otherwise in writing. So this is correct. uh, where the debtor fails to specify the application of payment, the creditor must apply the payment to the oldest outstanding debt, irrespective of whether the debt are barred by limitation, provided they do not violate any existing judicial interpretation or debtor's intent. This is also correct. If a debtor makes partial payment on multiple loans and there is no agreement or stipulation regarding the application of those payments, the bank is required by law to apply the payment proportionately across all debts, prioritizing those that involve unsecured obligations first, regardless of their relative standing in repayment schedule. This is not correct, because the bank does not have to prioritize unsecured debts over secured debts without specific instruction or agreement, um, making option B as the correct answer for this question. So thank you for watching the video. I hope you learned all about mandate, power of attorney, banker and set off and right of appropriation. If you are in the doubts, you can ask us on our Telegram group channel. But till then, take care and bye bye.